The other driver's insurance adjuster just called. Friendly, professional. They said they just needed a quick recorded statement to process your claim and get things moving. It sounded routine, like paperwork. Here is what you need to know before you call them back. Giving a recorded statement to the other driver's insurance company in New Mexico is not required. You have no legal obligation to do it. And what you say on that call can follow your case all the way to trial and cost you thousands of dollars. From years of working on these types of cases, I know exactly what adjusters are trained to listen for and how they use what you give them. That is what this video is about. And by the end, you will know the one call to make before you say a word to any insurer. So let me start with the question that matters most. Do you actually give a recorded statement? The answer depends entirely on which insurance company is asking. And that difference is everything. If your own insurance company is asking, you probably do have to cooperate. Almost every auto policy contains what is called a cooperation clause. It requires you as the policyholder to assist in their investigation, and that can include a recorded statement. Refuse your own insurer without a good reason, and they can use that refusal as grounds to deny your claim. That is a real consequence, and I am not telling you to stonewall your own carrier. But here's what most accident victims do not know. If the other driver's insurance company is calling and asking for a recorded statement, you have no obligation to give them one. None. They are the adverse party. Their entire job is to minimize what their client's policy pays out. And yet, they call early. Well, you're still dealing with the shock, and the tow, and the police report, and the first medical bills, and they make it sound completely routine. It is not routine. It is strategy. So let me show you that strategy the way I learned it from watching adjusters do it time and time again. When an adjuster records you, they are not gathering neutral facts to pay your claim fairly. They are building a record. They are creating a document that can be used against you at every later stage of your case, in negotiation, in mediation, and if it goes that far, at trial. Here's specifically what they're listening for. First, any language that hints that you've contributed to the crash. I think I was maybe going a little too fast. I'm not sure I had time to react. The light might have been changing. Any one of these can become the seed of a comparative fault argument from the defense or from their insurance company. Now, New Mexico follows pure comparative fault, which means even if you share some of the blame, you can still recover. And that is generally one of the strongest protections New Mexico gives you. But sharing fault still reduces what you recover. So why would you just hand the adjuster that argument, in your own words, on tape before you have even spoken to an attorney? That is the giveaway they're hoping for. Second, they're listening for inconsistencies. If you describe the accident one way today and your account shifts even slightly during a deposition 6 months to a year from now, that gap becomes a tool. You'll hear the phrase, but you said in your recorded statement. Adjusters and defense attorneys use it in their negotiations and depositions because it works. People say things early that is incomplete or a little off, not because they're lying, but because they're in shock. They don't have the full picture and they're trying to be helpful to someone who isn't on their side. Third, they're listening for you to downplay your injuries, and that one costs people the most in the first few days. Adrenaline hides a lot. Whiplash, soft tissue damage, nerve problems, disc injuries, most of these do not announce themselves right away. They surface over the days and weeks that follow. So if you say, I'm feeling okay, just a little sore on day 2, and you're reporting serious neck pain and limited motion on day 12, that adjuster now has your own voice on tape saying you felt fine, and they will not ignore that gift. They will play that clip back to your negotiation, and if it goes to a deposition, they will read it to you line by line and ask you to explain how you went from fine to injured. It puts you on the defensive about your own body over an offhand comment you made when you're still in shock and had no idea what was actually wrong with you. I have seen them use that recording exactly to get things that way, and that is simply how the system works. And knowing it coming in is half the battle. And one more thing they want you to say something quietly shrinks your claim. Ask what hurts, and if you only mention your shoulder, you've just created a document suggesting your back, your head, your hip were untouched. Even if they were not, document everything with your doctor from day 1. But do not try to summarize injuries that you don't fully understand to a stranger whose job it is to pay you less. So understand what that recording actually is. It's a fixed point. It exists and cannot be unrecorded. And your case is going to change in ways you cannot predict from where you sit right now. Your diagnostic gets more specific as doctors run tests. Your understanding of the crash sharpens once you've seen the police report and talked to witnesses. The full scope of your damages develops over weeks or months. But that early statement is frozen at that exact moment that you knew the least about your own situation. And opposing counsel is counting on that. I've talked to people who gave a recorded statement within 48 hours of the crash, and only later they found out the other driver had run a red light that a traffic camera caught cold. They didn't know that when they spoke. They were guessing. And some of what they guessed ended up on the defense file as evidence of their shared fault. This isn't about honesty. Honest, cooperative, well-meaning people give statements that hurt their own cases all the time. The problem is never the honesty. It is timing and preparation. Even the statement to your own insurer deserves care. Yes, you usually have to cooperate under your policy, and you have to be accurate and truthful. But accurate and truthful does not mean you have to speculate about pain levels before a doctor has fully evaluated you. And it does not mean you have to characterize the crash before you have reviewed everything available to you. There's also a real wrinkle in New Mexico. If the driver who hit you had no insurance or not enough, you will likely be filing against your own underinsured motorist coverage. And in that specific claim, your own insurer becomes an adverse party. Same company, but now their financial interest is paying you as little as possible. New Mexico has one of the highest uninsured driver rates in the country. So this is not some rare edge case. It is common, which means that you should understand exactly what kind of claim you are in before you assume your own carrier is fully on your side. So here's one call to make before any of this. Before you call the adjuster back, before you schedule a recorded statement with anyone, call an attorney. That call is free. Most personal injury attorneys, our office included, offer a free consultation. You can find out whether you even had a case, what your actual obligations are under specific policy, and where the risks are before you agree to a single thing. When someone calls me before giving any statement, I can walk them through the likely questions and help them prepare if their own insurer requires cooperation. When someone calls me after a statement has already created a problem, my options become a lot narrower. The right call is before, not after. And understand why they push. The insurance company knows the first few days are when you are the most vulnerable and the least informed. That is exactly why they call you then. Before you've talked to anyone actually on your side, you have the absolute right to say, I need a few days. I'll get back to you. You have the right to say you want to speak with an attorney first. Use it. If you want to hear the other lies adjusters tell to shift the blame onto you, I broke that down in another video. Watch that one next. If you're in an accident in New Mexico and want to talk through your situation before you say anything to an insurance company, call us at Hudson Injury Law, 505-416-4150. Consultation is free. Drop a comment and tell me, did you know you could say no to that call?